Tonight on Bayou Time, we'll bring in Fred Fondren, a local attorney here in Terrebonne Parish. There you see Fred. And we'll talk about a proceeding that took place today in St. Charles Parish concerning Andrew Robison, the quarterback who left Vanderbilt and tried to get on with Hahnville. He has not played a snap yet. But today, in front of a judge in St. Charles Parish, some of the proceedings going in favor of the young Robison athlete. We'll talk about that and more tonight on Bayou Time.
Deep in the heart of the bayou, we are gathered here tonight. Now it's time for action, 'cause our lives are on the line. Tonight we'll do our very best to break through all the bureaucratic mess. The time has come tonight, 'cause it's Bayou Time. Show what Louisiana's all about.
Now, from the Eugene Folse Studios in Houma, here's Martin Folse.
All right, welcome back, everyone. Martin Folse here once again with Fred Fondren, local attorney here in Terrebonne Parish. And Fred's been on the desk helping us out with the case of Andrew Robison, who, of course, by now, most people know he was a star quarterback at Vanderbilt Catholic High School. And the family tried to transfer to Hahnville, and in between all of that, all kind of things took place, and the young athlete never took a snap at Hahnville. There have been proceedings that have taken place. There have been injunctions. There have been lawsuits. A lot of things have taken place. Today in St. Charles Parish, in the courthouse, in front of the local judge there in the area, Judge Marcel, the lawyers got up and they argued their cases, and we heard the judge speak. Now we'll take a short break. When we come back, Fred's going to break down the court analysis, and we also talked to Drew Robison, the father of Andrew, and also we talked to the attorney for the LHSAA, and his name is Mark Boyer. So we heard from both sides. We'll have that when we come back. Don't go away. All right, welcome back. As today we spent some time in St. Charles Parish where the ruling was taking place on Andrew Robison, star quarterback at Vanderbilt Catholic High School, former quarterback who was attempting to transfer to Hahnville. Today was a big day in the courtroom in front of Judge Marcel. Joining me now, Fred Fondren, who has joined us many times here in the desk. Fred, good to have you back.
Glad to be back.
All right, we both were there. I spoke to Mr. Drew Robison, Coach Robison, the father of Andrew. We'll hear that in a little bit. I also spoke to Mr. Boyer, Mark Boyer, the attorney for the LHSAA. Whole lot of things happened in the courtroom today. I, like others, looking at it going, what's going on? Fred, what happened in the courtroom today?
Well, the short answer is the judge denied all the LHSAA's exceptions and kept jurisdiction of the case and venue of the case, and said that St. Charles Parish was a proper venue for the case. Now, the case as it stands now is a little different than what it was when the day started. The first thing that happened in court was the Robison's attorney came in and actually withdrew the request for a preliminary injunction. As you might recall, the temporary restraining order expires at the time of the hearing. That's the law. That's why you have a hearing for a preliminary injunction. They realized, I suppose, that the preliminary injunction, even if they were successful, if issued at this point, would not get Andrew on the field. It would likely be appealed, so that legal issue wouldn't be resolved, and of course Hahnville wouldn't play him without that issue resolved. They believe they have a better shot at getting the arbitration resolved on a timely manner, and if Hahnville makes the playoffs, potentially get him on the field.
So if you're, listening or watching from the perspective of the Robisons, and there's still other sides. Once again, we only have two factions in the lawsuit that have actually filed their I guess, answers, so to speak. So
that's correct.
We still have two others going on, but if you're on the Robison side of the ball today, it was a good day for you.
It was. It was I suppose, a small victory. The judge didn't make any judgments on the merits of any of the allegations, but based upon the allegations themselves, he did retain jurisdiction over the case and stated that St. Charles Parish was a proper venue in the case. That seems to be an advantage for the Robisons, at least at this point, but the judge did make some reasoning in so far supporting his decision that to me seemed a little bit questionable, and is probably going to get addressed by LHSAA and the Court of Appeal.
Yeah. So, and we did talk, and I'll play that soundbite in a little while, but Mr. Mark Boyer, the attorney for the LHSAA, did say they would appeal the case. I mean, looking at it from your standpoint, sometimes cases go to the appellate court, and the appellate court says there's really nothing overturned. The judge ruled on the merit. Probably a lot of gray area here, because I don't think any district judge is used to getting LHSAA cases. Is that, and he did have a line of questioning to the LHSAA about them being a private enterprise, so to speak, instead of a state or a quasi-state.
Yeah, the judge really skipped through that pretty quickly. The LHSAA used the Menard case, which was a previous Court of Appeal case that established that the court did not have jurisdiction to basically overrule the rules of a private organization. And LHSAA's position was, this is a ruling by a private organization. Our rules are approved every year at our convention by our members, which are the high schools. Everybody agrees to play by these rules. Everybody agrees to our authority to administer these rules. And if there's a dispute, it goes to arbitration. This is just simply not a matter for the courts to handle. Our rules are not set by legislation, the Constitution, or anything else. The Menard case supported that position. The judge really seemed to skip over that pretty quickly.
Now, the arbitration that they're going to go to now, which is going to be the case, Hahnville and the LHSAA are going to be in arbitration. It's my knowledge that that arbitration is binding to both parties. Is that correct?
It is, and that's why I believe the Robisons ultimately dismissed their request for the preliminary injunction. The arbitration is binding. There's no appeal from it. So if that were to happen next week, the week after that, or even presumably sometime before the playoffs were over in the event Hahnville would make the playoffs, that ruling would be binding, and if it went in favor of Andrew Robison, there's a chance he could get on the field. In the courts, if the judge would have even granted their preliminary injunction request today, had they gone forward with it, LHSAA would likely appeal that ruling to the Louisiana Fifth Circuit. That would almost certainly take several weeks, even if decided on an expedited basis. It'd be unlikely that he'd be able to play, even if it ultimately came down in his favor.
So all these rulings today might be the quickest way to get young Andrew Robison a chance to play. The way it went down.
The way it went
if
down.
If the arbitration works out.
That's right. Assuming the arbitration would come down in their favor, in Andrew's favor, well, in Hahnville's favor,
right,
then yes. The Robisons are not part of the arbitration.
Correct.
That is between Hahnville and the LHSAA.
All right, hold that thought. We're going to take a short break. When we come back, we're going to hear from the father, Drew Robison. He spoke with us shortly after outside of the courtroom. We'll hear from him, and I'll let Fred sort of dive into the legal part of once again a hearing today in St. Charles Parish. We'll be right back. All right, welcome back, and as promised, once again, Fred Fondren on the desk with me, and we're talking about a case today in St. Charles Parish. And what I want to do right now, we had a chance to talk with Drew Robison, who was a former coach at Vanderbilt Catholic High School, and he and his family were trying to get their son into Hahnville High. Of course, you know all the court cases and everything that have taken place since then. Lawsuit's been filed. After the ruling today, we caught up with him outside the courthouse, and I want to play you all 4 segments of his interview, because we've always said we want the other side to comment so we can be fair. So we want to be fair. We've yet to hear from Vanderbilt and Coach Atwell and Hahnville, but at least this would be the second part that we hear and present here on HTV.
feel like David did a great job, made the arguments that were important. At the end of the day, we're looking to the law to make this right, and I'm not sure that what parish we're in should matter, but I feel like this is as he stated inside, it's a property right issue. It's not just a matter of a student who wants to claim that playing football is a right, but when you have potential future affected, there are some significant opportunities lost in this decision. So I thought David did a great job making that case today.
Obviously, it doesn't make a difference as far as whether Andrew's getting on the field or not, but I guess is it some small satisfaction that at least it sounded like to me that the judge was sympathetic with your side, and because he said more than beyond what rulings there were. Right,
and I think you never know. I mean, I think throughout this process, a lot of things have been sort of surprising and maybe a little odd. And so the fact that I think this morning we were under the impression that arbitration was going to be put off, and of course I'm speaking of between Hahnville High School and the LHSAA, whereas it seems like there's a little bit better chance that might get sped up a little bit, and arbitration actually could get him back on the field. My understanding right now is, Hahnville's got 3 games left, and there's a chance they make the playoffs. So you never know. There's always a chance. So we're hoping to get him on the field, and we realize that may be tough to do, but we're just pleased that some wrongs are at least trying to get righted a little bit.
And that's why you pulled. You didn't want a decision.
Yeah, I mean to go through with a hearing for the preliminary injunction really in effect would do no good for Andrew. So that was really the thinking there.
Lastly, for me, 8 weeks into the season, I guess, has it been easier to deal with as it goes along, or is it still you wake up every morning and you got the tight feeling?
Well, certainly the daily intensity has probably lightened a little bit in terms of the stress and the pressure. I think the overall situation has been pretty steady throughout. In some ways, with the daily stress not quite as intense, in some ways that makes it a little bit harder, because sometimes you feel like, gosh, are we still doing everything we can do? Are we still fighting as hard as we can fight? And, sometimes it's kind of like a marathon. If you're at mile 5 and you're sprinting and you feel like you're about to die, you're going to be in trouble. And so it's a little bit more of a long distance race for us. And so, it's been refreshing in some ways. I got to visit my daughter at college this past week. So just kind of getting away, breathing a little bit, trying to be a normal person is probably healthy for all of us. And so, anyway, it still is what it is. It's still just as wrong as it's always been. And obviously, beyond Andrew, I'm hopeful that some changes can be made in the state, because the reality is every high school in this state is subject to an organization that has no oversight in effect, and that's a scary thing for everybody.
All right, we'll have more. He's had more comments for us today. We're going to get to that, but I want to sort of break it down so Fred can have a chance to comment. He mentioned property rights issues. I'm not sure what all that means, so I address it to you. And obviously, you could tell by his demeanor today that he was satisfied with what happened in the courtroom today. What did he mean by property rights issues?
In order to have a constitutional claim or a legal right to pursue, you have to have a legal interest or a property interest in that right. It's not something that you can just make up. That was discussed in some of the exceptions filed by LHSAA. You don't have a right to play football. You don't have a right to have a scholarship. All of which is true in the case law. The court, frankly, and this is both by my review of the case law and my observation of what happened in court, really strained some of the reasoning to determine that there potentially was a property law. Of course, he didn't conclude one way or the other. The judge didn't make any conclusions of fact today. Everything he decided today was assuming that the allegations were true.
In fairness to the judge, you think maybe he was going out his way to give a young kid maybe a chance to play?
I can't speculate on his motivation, but I can say that there's been case law that says that there's no property right to play football, and somehow today he came up with one, or at least the potential for one, the potential for a property right in a scholarship that doesn't exist, and also deprivation of those rights. The other thing that the court did was speculated about some of the allegations of religious discrimination and how that could be a constitutional violation. The difficulty that the court, I think, kind of skipped through, and something that the Fifth Circuit will have to address when the LHSAA takes it up, is that you cannot have a constitutional violation by a private actor. You need state action for that. You need a state government, a state agency, a public school, something like that.
So a constitutional issue cannot be, in your opinion, a person against a person? Is that what it is?
It can't be between two people, two private entities, a private person and a private business. It has to have a state actor involved, a governmental actor involved.
So that's why it was important when the judge was questioning the LHSAA about whether they were quasi-state or private. That's what he was trying to get to, I guess.
Yeah, the judge really, when I say strained reasoning, here's kind of what I'm getting at. He said that it was the potential for the LHSAA to be a quasi-governmental entity because it ruled on things that affected a potential property right and used the existence of the property right and a potential constitutional violation, the same potential violation, to try to say that the LHSAA was potentially a quasi-governmental entity. So both of those seem to be strained lines of reasoning that relied upon each other. They also both were contrary to case law. I think that's probably what Mr. Boyer, LHSAA's lawyer, was expressing after the hearing. I understand there's some video on that as well, and I'm sure he can explain himself better than I can, but that's, I believe, what he was getting at.
Yeah, let me roll in some more footage real quick for the break of the father again, Andrew Robison, commenting to me outside of the courthouse.
We're grateful for today. We're grateful for Judge Marcel and really grateful for David Moyer. He's done a great job for us and really just out of the goodness of his heart, honestly, has reached out to Andrew, and we really are happy about that. And, you know, honestly, we want to move forward to a trial. I know nothing has been said today specifically about the allegations regarding Jeremy Atwell or Vanderbilt Catholic, but we're really anxious to get to trial for that as well, because there's a lot of justice that we have yet to see about Vanderbilt Catholic. So we're hopeful that that will come to light soon.
Okay, and I want to really get on this subject, because after we quit rolling, Drew told me, I noticed y'all haven't done anything on Coach Atwell, meaning that we've been sort of neglecting the Coach Atwell side. We don't have anything on Coach Atwell. They haven't answered the lawsuit. There's nobody, even on their side, I'm talking about the Robison side or Hahnville side, that's brought us any credible evidence of anything that they've alleged. So we really have nothing to report until we get to the court or we get to the findings. So we have nothing. But you could tell by the interview they're moving forward, and he specifically mentioned Coach Atwell.
Well, as we've discussed before, we've tried to limit our analysis to the documents, to the allegations that have been made in court. Neither Vanderbilt nor Coach Atwell has filed a response to the lawsuit, either an answer, exceptions, any objections, or anything yet. So we don't yet know what Vanderbilt or Coach Atwell's official position is going to be, whether they'll potentially make even any responsive claims of their own. We don't know that yet, and we can only speculate about it, which is why we hadn't.
But in fairness to this station and you and I trying to report the story, we have reported what they've said in their, what the Robinson said in their lawsuit. So if they alleged that the young star quarterback was bullied or whatever, we put all their allegations out. We just haven't got the other 50% of the equation, like we said, back. So until we have 100%, it does make it a little difficult.
Of course, and I look forward to receiving the responses from both Coach Atwell and Vanderbilt so that we can put everything, in an overall context.
Right. So I want to play the last part. I want to give him full tilt here because we've said anybody. We invited all attorneys, everybody on all sides to come forward and speak out. So let's roll the last part of the interview with the father. Arbitration comes into play now. I guess it still moves forward. I'm sure, the other side said they would appeal the ruling, but I know your hope is to get something quick because there's 3 games left and there's playoffs. So are you hopeful, or do you think it'll happen, or what's the process to get that speedily done?
Well, there's nothing I can do. I'm completely powerless. And as far as my hopes, my hope is in the long run that we as a family would act responsibly and that we would handle ourselves as best we can, that Andrew would continue to do that, and he's done a tremendous job from the beginning of this ordeal. And so, my hope is that the arbitration would rule in Hahnville High School's favor because I think they have a great case. But that's my hope. I don't have the ability to predict that because I just don't know how things work. I mean, I'm encouraged a little bit that a third-party arbitrator has been selected, and that's somebody that's going to be very familiar with the law, and hopefully somebody that's not predisposed with some sort of political pressure to judge in favor of the LHSAA, which I believe the executive committee was. Mm-hmm. So, I do expect and I do hope that an arbitrator is not going to behave as the executive committee did, which was basically not listen to anything and do what they already decided they were going to do, which that was embarrassing for the principals involved. That was really embarrassing for them.
All right, there you heard it from the father. We'll take a short break. When I come back with Fred, I'm going to ask him about venue and also about, you heard the father's comments, pretty targeted towards the LHSAA and the way he thinks they handle things. We'll be right back. All right, welcome back. Martin Folse with Fred Fondren. We're talking about the court case today in St. Charles Parish, that if you're on the Robison side, well, you take that as a slight victory. In this thing, there's so many different avenues that it goes on and on and on, and every week we're on, it seems like we're at a different angle. But let me ask you this, Fred. The venue, how important was it for the judge to say, no, this case can stay right here in St. Charles Parish?
Well, we heard Mr. Robison say that the venue shouldn't matter, but clearly they filed the case in St. Charles Parish. It must have been meaningful to them in some way. The judge went out of his way, in my judgment, to keep the venue in St. Charles Parish. What he said essentially was that the venue rules say that if there is what's called solidary or joint liability, meaning all the parties can be liable for the same harm, for the same act, or out of the same circumstances, that they can all be sued in the same parish. The problem is that neither in the original petition nor in the amended petition was any solidary or joint liability even alleged. So the judge seemed to supply that allegation for the Robisons on his own. Secondarily, one other piece of that is that the amended petition, although the judge seemed to refer to it in some of the constitutional violations, the freedom of religion alleged in the second petition, or the amended petition, that petition actually is not yet part of the record. The ability to file that petition was contested by LHSAA, was not agreed to by the other parties, and the court never set a hearing on it to even allow it to become part of the record, yet apparently relied on some of those allegations to support his judgment today.
All right, there you have it. The cycle continues. So we're going to continue bringing you up here, follow this case, a very interesting case. Fred, thank you again for joining us, and we appreciate it.
Glad to be here. Thank you, Martin.
All right, we'll take a short break. When we come back, more here on Bayou Time. Stick around. Don't go away.